Back, it's exactly 17 after 9 o'clock, and we're now going to be joined by Anjuli Maistry, Senior Attorney at Equal Education Law Centre. And we're going to be looking at the recent Supreme Court of Appeal ruling on corporal punishment in South African schools and its implications for child protection. Anjuli is a senior attorney, and it's a pleasure talking with her once again. Morning, welcome to the program.
Hi, thank you very much to you and your listeners for having me.
Lovely talking with you again, Anjuli. When I read this headline, I was actually quite shocked. I thought that corporal punishment had ended decades ago. Do you mean that it is still happening in this day and age?
It is still happening, and I think that this is why the judgment is so important, is that in spite of the fact that it was banned all the way back in 1997, it continues to be quite prevalent used in schools. And so we need to try to look at every different angle that we can to try to eliminate its use. And so this court case is just one of the ways that we can try to do that.
Can you explain to our listeners the significance of the recent Supreme Court of Appeal judgment regarding corporal punishment in our schools?
Right. So for that, I think it might be good to just take a few steps back to explain the background to the matter. So two parents and the Centre for Child Law, which is based at the University of Pretoria, approached the High Court just a few years back. And their issue was that their children, who were very young, 7 and 10, were severely assaulted by their educators. And this was unrelated instances, so separate in two different schools. And one of the avenues that children have in instances of educator violence is to report the matter to the South African Council for Educators. And I'm just going to start using the term SAFE because it's shorter to say. And that is the Professional Council for Educators. And so what SAFE does when it receives a complaint is it investigates these matters, and it can make a decision on how to discipline the educator. And so in these two instances, SAFE handed down very light sanctions, which wasn't appropriate in the circumstances because of the severity of the assault. And so what happened there was that the teachers were given wholly suspended sentences of removal from the role of educators, and they were also given a fine, with part of the fine also being suspended, and then they were allowed back into the classroom. And so the parents and the Centre for Child Law approached the High Court to have these sanctions that SAFE handed down reviewed and then sent back to SAFE to be reconsidered. And they wanted to do that for a few reasons. The first is that SAFE failed to protect their children's rights, failed to protect their best interests, and didn't consider the fact that their best interests are of paramount importance. Didn't consider the fact that the children weren't allowed to actually make any representations on what the sanctions were, and that the proceedings weren't child-centered. So that's why they wanted the matters handed back to SAFE to reconsider and to review. All of that is simply to say that the Supreme Court agreed with the parents and agreed with the Centre for Child Law that the sanctions by SAFE and that were handed down just needed to be sent back to them to be reconsidered.
Okay, so as I understand you, the judgment emphasized the importance of considering the best interests of the child in disciplinary proceedings. How does this principle, factor into the court's decision?
So it's super important there to talk about Section 28 of the Constitution. And that states that a child's best interests must be taken into account in every matter concerning a child. And so what the court did there was it reaffirmed this important right and principle that comes from the Constitution. And it also expanded on it, in a sense, by saying that what considering best interests means in this set of circumstances is that a child needs to be heard and participate in matters that are about them. And that since SAFE is an organ of state, they are bound to respect and promote the Constitution and to respect and promote the children's rights in the Constitution.
I understand that the court criticized SAIC's approach to disciplinary sanctions. The court called for more flexibility and consideration of rehabilitative measures. How do you think this will impact on future disciplinary actions by SAIC?
Thanks for that. So, for a bit of background to that, to understand how it will impact future disciplinary actions, when SACE finds an educator guilty of a particular type of conduct, any type of conduct, it sanctions those educators in terms of a particular document that's called the mandatory sanctions document. So that's where, in this specific instance, it got its sanctions from. So, we saw removal from the role of educators that was suspended and fines. They all come from the mandatory sanctions document. And one of the very important things that came out of this matter and that came out of the judgment was that when SACE sanctions educators for using corporal punishment, it now also needs to consider sanctions like rehabilitating the educator, and training them to stop using corporal punishment and to start using non-violent discipline techniques. And that's very important, because what it does is it doesn't just bluntly punish the educator, which isn't really the main focus of the sanctions in our view at least, but it actually ends up fostering meaningful change. It equips educators who return to the classroom with meaningful tools to use non-violent discipline, and that goes much a longer way to actually eliminating the use of corporal punishment, because like you said at the beginning of our talk, corporal punishment was outlawed a long time ago, yet it is actually still being used. And another thing that the court said was that when SACE has a discretion when it hands down sanctions. So it doesn't have to blindly stick to the sanctions that are in the mandatory sanctions document, but can use other sanctions when it thinks that's appropriate. And so it kind of transformed SACE's or confirmed SACE's how it is able to discipline in the future.
So, Leila, help me understand. Initially, the High Court rejected the review request due to perceived delays. Can you clarify why the delay occurred and how the Supreme Court of Appeal addressed this issue?
Mm-hmm. Right, so essentially there wasn't really actually a delay. It was a technical point that was taken up by SACE. So the parents had, when you bring court proceedings of this nature, one of the things that you have to get before you are able to launch these court proceedings is the reasons that SACE gave for its decision. So why it made a decision to remove them from the role of educators and suspend that and the fine, etc. And so the High Court said that the applicants, there was a delay with the applicants bringing this court case, but the Supreme Court overturned that and correctly stated that the parents didn't delay in bringing the matter because it was correct to only bring the matter when SACE's reasons for the decision became available. So it was a largely technical point.
Are you confident that this judgment will positively influence the broader conversation around corporal punishment in South African schools?
Yeah, that's a very interesting question. And I think it's interesting just because corporal punishment is quite deeply embedded in our society. I mean, a lot of the comments that I've been seeing since this judgment has been handed down and in other conversations concerning corporal punishment is that a lot of parents and educators really turn to it as something that they don't see an issue with and that they use. But, it has a small effect. So the real effect of the judgment is that it creates meaningful change and long-lasting change because firstly, it demonstrates to SACE that it can impose sanctions in these instances that actually show educators how to use non-violent discipline. And that makes a difference. Every educator that is trained not to use corporal punishment and to instead use non-violent discipline techniques means that we are slowly shifting the balance, even if it's slow, towards a non-violent culture in which children are safe and protected. So I do have some confidence, yes.
Okay, great. Though I still can't believe that in this day and age, corporal punishment is being used. But that being the case, what steps do you believe SAIC should take moving forward to ensure that corporal punishment is effectively banned? And the operative word here is banned, and that educators are held accountable. Another operative word, held accountable for their actions.
Mm. Yeah, so I mean, we mentioned at the beginning of the session that corporal punishment has actually been banned. But I guess the problem is that although it's banned in all of our legislation, it is still very widely used. And recent stats that were placed in the court papers demonstrate that of the 1 million children who experienced corporal punishment, 84% of those children were experiencing it in school. So it's still widely used in school. And so it's very important to ensure that educators are equipped to use other ways of disciplining children. And then another thing that's really important, and one of the other things that the appellants and the amicus curiae were asking for, is that the mandatory sanctions document that SACE uses when it sanctions educators must be revised, reviewed, and developed to include equipping those educators that use corporal punishment to use non-violent discipline for the reasons that I said before. It helps to slowly shift towards a non-violent discipline approach and to eliminate the use of corporal punishment and create safe classrooms. And that's the important thing, because that's what will keep children safe when educators return to the classroom. I think it's just important for me to say one more thing over here, which is that when educators are severely violent, as they were in these two cases, it isn't actually appropriate for those educators to return to the classroom, generally speaking. So we're talking about instances where it is appropriate for educators to return to the classroom where such severe assault wasn't used, and where educators can actually be rehabilitated. So so when severe assault is being used, educators shouldn't return to the classroom, and that is in a sense how they're held accountable. To go back to your question, and yes, sorry, go ahead.
Layla, just for the record, remind us how severe was the assault on those two specific learners that resulted in this case going to the High Court, because I can't seem to recall it. Can you just give us an overview of what what the punishment looked like?
Yeah, okay. So in the case of the 7-year-old child, the teacher beat him with a PVC pipe, and that led to him being rushed to hospital eventually.
Oh.
And the doctor thought that he had suffered a hemorrhage, which had then become infected. So his life is quite different according to what was pleaded in the court papers by his mother. She says he's no longer vibrant, he's no longer confident, he can't focus or concentrate in class. And in that instance, SACE imposed a sanction of removal from the role of educators, and that was wholly suspended. So that meant that it was the sentence wasn't implemented and would only be implemented if the offence was repeated again. So that means that the educator went back into the classroom. And then there was also a fine that was imposed, and that was partially suspended, meaning that some of the fine didn't have to be paid, would only have to be paid if the teacher reoffended. And then in the case of the 10-year-old child, she was smacked across her cheek and then hit on her head, and she bled from her ear. It turned out to actually be recurrent bleeding and resulted in numerous hospital visits. And so she missed a lot of school days, and her academic performance suffered, and she ended up having to repeat that grade. And then SACE imposed the exact same sanction as the one that I just described to the other educator.
So in these situations, the parents could also sue the Department of Education for current and future costs, damage to the child and the child's future. I mean, this is so serious. I didn't realize just how serious these two incidents were. But you've also mentioned a number earlier on, suggesting that up to 1 million school-going children are assaulted at some point in their school lives. That is horrendous. That is, I can't even wrap my mind around that figure. Surely these teachers, when they are in training, should be given training in how to handle children, in how to deal with possibly issues of disobedience, but not violence, not physical violence. And they need to be also told how serious this is taken, and they could possibly end up in serious end up with serious legal issues if they continue to do this.
Right, and I think I think you're really getting to the core of what the issues are here, is that educators are not well equipped to manage classrooms and to use non-violent discipline techniques. So that's, the use of positive reinforcement, telling a child and repeating when a child has done something that's good. So encouraging them in that way to make use of positive behavior, trying to understand what the root cause of any behavioral issues are and addressing the root cause of those issues, using counseling, making sure that children feel heard. And so I think that those are things that educators really need to be better equipped to use in order for us to kind of try to make some strides towards corporal punishment not being used and not being the default that's being turned to by educators.
And finally, can you talk to us about the role of organizations like the Centre for Child Law in advocating for children's rights and, of course, also promoting nonviolent disciplinary practices in schools? Question number one. Question number two, we have the converse as well, where older learners or students, we've heard and seen many such reports in the media, where older children are also attacking teachers. Would that fall under the ambit of your centre? So 2 questions there.
Yeah, okay, thanks. Right, so I'm from the Equal Education Law Centre, and we represented the Children's Institute as an amicus and also provided an expert affidavit from Peace Discipline, and then the organisations that brought the case for the Centre for Child Law in Section 27 and the parents. And so these organizations do a range of different things. So research on corporal punishment to understand its causes, to lobby for better laws, to lobby for better practices, which is in this particular court case, what these organizations are trying to achieve and attempt to accomplish here. And there's the training of educators to use nonviolent discipline. So that's the role of peace discipline. And we also represent parents directly and learners and attempt to hold the department and bodies like SAFE accountable to their constitutional obligations. In respect of children attacking teachers, that isn't exactly our mandate, but I do think that because of the concerns that have been brought up in all of these conversations about the fact that teachers are also not safe in their school environment, it is potentially something that we need to start understanding the root causes of, so that we can ensure that schools end up being safe spaces for teachers and for children too.
Is this situation that you and I have discussed this morning unique to South Africa, or does this happen around the world?
Unfortunately, it does happen around the world.
Yeah.
They've been, in fact, in some countries around the world, like the United States, corporal punishment is not 100% outlawed in their legislation. And that's the case in a number of other countries too. And in countries where it has been outlawed, legislation, the practices continue to remain on the ground. So that's why it's so important to continue to make strides in all of the different arenas that you're able to. So, for example, making sure that it's entirely outlawed in the legislation. And then once it's outlawed in the legislation, making sure that we're making strides that is implemented and that teachers are actually equipped to be able to not use corporal punishment in the classroom, because it is a global phenomenon.
Sure. Okay, so to wrap up, I'm going to throw something else at you. I'm thinking as a parent, we prepare our children for school, for the starting of their school life. Are there anything specifics, are there specifics we should kind of, entrench in them, like, and I suppose it is, one should be talking about mutual respect, not being a bully, and just, I guess the key word here would be mutual respect. And of course, not to bully other children, and just understand that they, as human as you are, they have feelings just like you do. So they wouldn't want to be hurt. So don't you hurt other people, and other people won't hurt you.
I mean, I suppose that means that I'm stepping out of the realm mostly of my hat as a lawyer and stepping into my role as a parent when I say that there's a lot that we have to do as parents to make sure that our children are equipped not to use violence themselves. And what I think is so funny about this whole conversation is that corporal punishment actually has numerous effects. Corporal punishment itself, the corporal punishment at home, corporal punishment, when educators use corporal punishment, one of the effects of that is actually behavioral, and it's aggression, and it ends up contributing to cycles of violence itself. If we don't make sure that we're not using it in all of our different spaces, so that's home and school, it ends up being a cycle that we are unable to kind of get ourselves out of. And so that's why I think that it's so important that this is a conversation that we have that spans not only the school space, but also the home space. So it's something that we are able to actually eliminate holistically.
Absolutely. So parents do need to play a very crucial role
There's a role for everybody.
Yeah, absolutely. Absolutely. I'm just thinking and how important the teacher's role is, because little kids almost idolize their teachers. And if the teacher puts them down and calls them stupid or whatever, that's going to haunt them for the rest of their lives. And, depending how strong-willed or how strong the child's self-esteem might be or might not be, it will either make or break that child. And some children, as we know, Layla, won't even come home to talk about what had happened in school because they're embarrassed, they're ashamed, because they think they bad, because the teacher said that they stupid or they bad. So there are so many layers to this discussion and to the child that has been punished or being bullied or picked on by the teacher. And that's the other issue as well. We don't have time for it today, but I'm thinking about apart from corporal punishment, when a teacher picks on a child, a particular child, repeatedly, the repercussions on the child, not only, the self-talk of the child, but what the other children then pick up on and then starts teasing and bullying that child. That's a very serious situation as well, is it not?
Yeah, absolutely. I mean, and these are some of the things that we're seeing coming through our walk-in clinic. Quite unfortunately, there has been a consistent number of cases that have come into our clinic concerning both bullying, inter-peer bullying, and also bullying of educators who are bullying children. And you hit on something that's very important there that actually comes from studies itself, which is that this does impact self-esteem. It's not something that we're thinking, but something that's been studied and is a conclusion and an impact of corporal punishment. It impacts your self-esteem. It turns you into a bully. It means that you start demonstrating aggressive behaviors and anxiety and essentially kind of places us into a cycle as a society.
And a vicious cycle at that. So these little darlings that were so innocent that we sent off to school then come out of the system being bullies themselves, or so damaged that they go on hurting other people in their day-to-day lives. But that's where we have to leave it. Layla Maistry, thank you indeed. Always a pleasure talking with you. And
Thank you.
I'm sure we will be talking again sometime soon. Layla Maistry is Senior Attorney at Equal Education Law Centre, talking to us about the recent Supreme Court of Appeal ruling on corporal punishment. Thank you once again for your insights on this matter. You go well and God bless. Okay, it's exactly 9:40, news and views on Solar Media. And we're now going to be looking at that very heartbreaking story, the 10th anniversary of Nigeria's Chibok girls that were kidnapped. Sadly, there are still 82 of those girls that are unaccounted for or are still missing today. We'll be talking with Dr. Abdul Rahman Abu Hamisu, lecturer with Department of Political Science and International Relations, University of Abuja.